Hello, ladies and gentlemen, dear community. Thank you very much again for watching our SAP IP Business Talk. Today, so after a longer break, because we had the feeling that you needed the break and we needed a break, and we reorganized a little bit our format, but we promised to be back, and this is the next wonderful live interview here on LinkedIn with Nora Rehakova. She's located right now in Prague. And so this time we stay in Europe. So for everybody, it's 5 o'clock, I hope at least, in the afternoon. And as we see in Prague, we have wonderful weather. So very bright window in the back from Nora. And so Nora, please explain us a little bit. What is your background? Where you're coming from? What was the way how you came into that sometimes a little bit strange topic of intangibles, intellectual property, data, and what you're doing now and where, and let us learn a little bit more about you.
Sure, thanks, Alex. And hello, everyone, and welcome to this IP Business Talk. Thank you for having me, by the way. My name is Nora Rehakova, and I'm the European Data Protection Officer at a company called Organon. We are a pharmaceutical company focused on women's health. Before I joined Organon, which is something like 1 year ago, I was working as a data protection officer for a company called Showmax, and we were a direct competitor to Netflix. I've spent there almost 4 years. And when I was working before for a company called MSD, which is a large pharmaceutical company, I was studying at the same time at the Strasbourg University, the course which is led by Alex. And I was studying intellectual property law and intellectual property management. I came into that program as a lawyer. I have a legal degree obtained here from the Czech University. Then I was studying business administration, and then I was studying this course on intellectual property law and intellectual property management. I obtained my diploma. It was actually a life-changing course, sort of, especially for us who don't have the technical background. My schoolmates were mostly patent attorneys. So for them, I think the business part of it was something new, which was not that new to me, given that I came from business, plus I was studying business before. And I found that really interesting and at the same time, a little bit overwhelming, to be honest. And then I came back to Prague and I was thinking what I'm going to do. And I tried to apply for several positions. And I think that IP in particular is available to people who have the technical background, which I still don't have. So I was not very competitive in that area. And I have decided to change my main focus to data protection, which that was a big topic back in 2017/2018. GDPR was coming into force in 2018. And I actually had to decide to jump into a new arena, which was data protection. And this is where I ended. And I'm very happy for that change. And I still see many parallels between IP and data protection, and also data protection and IT security. But this is where I am, and this is where I come from.
Yeah, I mean, it's also very intangible, and it's a specific spin on intellectual property. Has something to do with know-how protection, and I mean, yeah, it's a certain formal. It has certain formal aspects, but also very business orientated, basically. So I would like to come to the first question, which leads me to data protection has a lot to do with digital transformation, and it started in the mid 2010. Late 2010 years with this discussion on data privacy and this kind of aspects where everybody used the personal data on Facebook and the social media. We got that discussion, and then a big discussion around GDPR and what happens with data which is collected by companies. But basically today, nobody is in doubt that data is really a source of customer benefits, of productivity in companies. It drives value chains. It drives whole business ecosystems. And so the World Economic Forum assumes that over the next 5 to 10 years, more than 70% of the value creation will come out of the usage of data. I mean, that is saying that we observe that many companies undergo a digital transformation. So you can say more or less every company, maybe the digital transformation is already there and maybe it's big, but basically every company has to adapt to this environmental change of the digital technologies and has to create some competitive advantages out of using that. And so you need, for successful business, you need to protect data. I mean, that's an interesting concept. Yeah, protecting data. That is hopefully something which you can explain us a little bit. But so the companies need obviously competencies, capabilities to do that. And for example, in manufacturing companies. And so, can you tell us what kind of capabilities, competencies are necessary, and do you think that companies overall are ready for that challenge?
Long question. Maybe before I jump into that part about capabilities necessary to deal with data protection regulation in general, I think that manufacturing companies as well as other companies, they have tendencies to look into data as an asset. But I think that it's very important to understand that the asset comes with a liability too. And there are these tendencies to really look at data as the new oil. There's this famous quote by Clive Hamby from 2006, I think. And he said the data is the new oil. And it was even developed further by a gentleman who was working for Gartner. And I think later on, 5 years later, he quoted that information is the new oil of the 21st century, and analytics is the combustion engine, which is interesting because, as you can see, in only 5 years, we were able to move from being able to refer to data, meaning raw data, meaning just some information unit not carrying any value, to information, which actually means that it's data which carry a value because it's data put together to create some value. But both of these quotes are more about like looking into data as an asset and not as a liability. But in reality, data have to be treated properly in order to derive the value and derive it securely and in conformity with applicable laws, which was the missing piece, which I was waiting for.
Just to clarify that, I mean, you mentioned that, and that rings a bell. That when we say always data is oil, or is the new oil, and that we have data protection. So from the pure definition, I mean, data is to a certain extent meaningless. That's the difference between data and information.
That's right.
And I think it's interesting because I mean, data, as you said, the question is, does that really have some value? And to a certain extent, without the context, without the analytics, without anything, it is just data. And not really helpful. And how is it? I mean, in these regulations, is it distinguished? Is there a distinguished definition between data, information, and know-how or knowledge?
All good questions. Actually, when we refer to data and information, especially in American companies, we use these terms interchangeably, but these notions are quite distinctive. When we talk about data, we really talk about data as per the European data protection regulation, whereas in the United States, they distinguish something what they call personally identifiable information. But they more or less mean the same. We still talk about data which relate to individual, to a living individual. So we are trying to protect a physical person and his or her rights and freedoms. Because in reality, the right to privacy and the right to data protection, these are two distinctive fundamental human rights. And we also use these two fundamental human rights interchangeably, privacy and data protection, but in reality, they are slightly different. But people don't understand data protection. They think that it's a IT security term. So rather we say privacy. So that rings a bell. But in reality, also people don't know what that means. But back to your question, GDPR does not distinguish between information and data. Personal data are defined as like data which can directly identify individual, or data which can in combination lead into identification of an individual as per Article 4. All the definitions can be found in Article 4 of the GDPR. So as you can see, it's a pretty wide definition of what constitutes personal data. And in this context, all companies, including manufacturing companies, have to understand that almost everyone is in possession of personal data, and hence actually in the scope of this GDPR regulation, which applies to companies which are headquartered here in Europe, or they have like their official address here in Europe, they are domiciled here in Europe, but also to companies which which resides elsewhere, actually anywhere, just in case that you process personal data of the European Economic Area residents, will kick in the GDPR. So you're a US-based company and you don't know anything about the GDPR, but still GDPR will kick in and will apply to that processing activity conducted by this US company. But GDPR does not distinguish between data and information. However, obviously, context is everything. So the harmful part of the processing is that context. So if you know that, like if we look back to my times at Showmax, like whatever content I was watching, obviously from the analytical point of view, we were looking into those details about my profile. And if I was watching content which was labeled as gay content, one would assume that maybe I am my sexual orientation is sort of like gay. So then if this information is misused, then someone can come up with the conclusion that Nora is gay, and I can be treated accordingly. So this is the type of harm we are trying to prevent with the GDPR.
Okay.
And yes, do you want to go back to the question about capabilities, or do you have more questions?
Yeah. I would like to stay a little bit with that aspect. So when we talk, I got the point, yeah. But when we talk about a classical manufacturing company, so it doesn't. So for me, it doesn't seem to be so harmful that they have, for example, data from sales representatives, or that they use data which they goes with their machines or something like that. So I mean, so basically we have to be a little bit more precise what exactly means harmful here, and especially what is the difference within the digital transformation. I mean, that is really the game changer. And can you explain us a little bit how that affects a classical manufacturing company?
Yeah, sure. I was thinking about this component, that this is a manufacturing company, but even a manufacturing company which may be of opinion that the core processing is about non-personal data, because typically the data which will be processed are some machines efficacy data maybe, which is definitely not personal data. The workers, those employees who operate those machines, they are people, physical persons, hence GDPR applies. And typically in manufacturing facilities, there are CCTV systems installed. So this CCTV, it will produce personal data, right? Because obviously these records coming from that camera surveillance system, it is installed there for maybe some official legitimate reasons, such as protecting health and the proper health of employees and the property of the employer. But at the same time, many other and here informations can be derived from that recording. So this can be particularly harmful, because if someone actually took a break and this break was longer than it was allowed, will this person be penalized for that? Will this person be laid off? So here it comes to the part when this processing can be harmful. It's about
And
setting
by the way, so
expectations
these guys who work with the machines, so typically they have to have a certain safety check. So they have to have the admittance that they are allowed to work with the machine or at a specific part of the machine, and they have to show that they have the right trainings, that they can do what they should perform, and what happens when they are ill, they are not at the job, so somebody else rushes in, should do that, and then we have an accident or whatever. So even in a very, let's say, normal production facility, you have exactly that personal data.
Yeah, you just tackled that. It's nailed down right there. Health data are considered as special categories of personal data, together with biometrics data or sexual orientation data or religious data. And the reason why we call them special is that if they are misused, it can lead to significant basically harm to rights and freedoms of individuals. So typically a discrimination can occur as a result of misuse of the data. So lack of possibilities, opportunities presented to those individuals who are either seem to be sick, or they are gay, or they are, they have certain political beliefs, for example. So this is where the harm can kick in.
Okay. Now I think we got it. It's really so. It's ubiquitous. It's everywhere.
It's everywhere. Yeah.
And so I mean that leads to my next question. And sorry for making it long, but I try to explain why I'm asking that. I mean, not just that people might think this has nothing to do with my company because we are just a producer of whatever. Yeah. So I'm not making business with data, and insofar it's not my issue. But de facto, I mean, also when we go, so just to mention, it's not a part of the question, it's just to mention that more and more the classical machine tool manufacturers, they change their business model to an operating model. So they do not sell anymore just a machine. They operate the machine within the premises and facilities at their customers. And so it is even worse, yeah, because this is due to digitalization, but that means that the operator knows who is working at the machine, and the guy who is working at the machine is not the employee of the operator, it's an employee of the company which produces something with the machine. So it makes especially the digital transformation makes those things much more complicated and complex. Just the next question. One thing is that obviously every company has to deal with it, and that the digital transformation makes it even more important. The next thing is that some people in the company thinks that they don't have anything to do with it. And especially, let's say, non-legal stuff. I know when you come out of the legal system, in the broadest meaning, you think everybody should be a lawyer or might be a lawyer, but typically that's not the case. So most people are far away from the legal system, and they don't think that especially legal stuff, has anything to do with them. So maybe like tax or so. and so how can we make sure that everybody understands that it is also his or her business, that nobody can avoid really to be affected of that. And then the second question, or the second part of the question, is how can we make them, how can we enable them? It is training, is it awareness? So what can we do that they can behave according to the law?
Yeah, this is also a good question and fair point. When I talk about this topic and when I think about it in general, we have data protection and data protection professionals. We have so much in common with IT security professionals, because in reality, anyone in the organization can cause a data breach or a security incident. So this is maybe a starting point, right? So this is how we can look at it, like whoever, it doesn't matter whether this is an administrative assistant or whether this is a CEO, anyone can cause a data breach, anyone can cause a security incident. So this is what we have in common with that discipline, which is actually a core of data protection, IT security. So I think that everything starts with the proper training. But these trainings, which are typically being conducted by external by third parties, by vendors on data privacy, they are too generic. People will not understand, like, how does it relate to them? So I think the key thing is to conduct trainings which are tailored to the needs and to the specific audience to which we are talking to. And we have to come up with narratives which will ring a bell, because people don't understand what is privacy. People don't understand what is data protection. So we have to help them to understand when the internal privacy office or the data protection officer or whoever is in charge of privacy in that respective firm, when this person should be consulted. And there are, I think, 3 checkpoints in every organizations which should be implemented anyhow, either by means of a formal process or by means of really a consultation. Just schedule a meeting and let's discuss the topic. So like these 3 checkpoints are as follows. When you onboard a new vendor, a third party, typically, as you just mentioned, like, for example, the vendor will send its worker to operate in the facility. So this is a processing activity. So we should actually understand who will do what, for what reason, and how long, and how this activity will be done. Anytime when this company, typically the employer, who acts as the so-called data controller, which means that this legal entity or physical person determines the what, how, and why with data, then it qualifies as a controller. This controller can actually instruct a processor, a third party, to act on behalf of the controller. But these types of relationships, they have to be properly managed, because otherwise this vendor will do whatever the vendor wants to do. And in that case, first, the vendor will not continue being a processor. It will become a controller, but it's another story. But with respect to this particular type of relationship, we act as a controller and the third party acts as a processor. As per the GDPR, there is this requirement to proceed with due diligence before you onboard that vendor. So anytime when you onboard a new vendor, if the vendor will process personal data, even if the vendor provides storage for data or has access to the data, it constitutes processing, and we have to proceed with due diligence activities, both from the data protection and IT security point of view. So I think this is crystal clear when you say anytime when you onboard a new vendor, please consult the privacy office. That's clear. People will understand, okay, I know what to do and I'm going to proceed then. And there is either a formal process or there is this like informal discussion with the privacy office. Both is fine. Then the second checkpoint is basically, we call it the privacy impact assessment. Anytime when you want to kick off a new activity, a new project, program, initiative, process, anything what contains personal data, Again, a privacy office should be either consulted or there is a formal process in place how to assess, like, again, who will have access to the data, for how long the data will be processed, what data will be processed, what is the reason. So all these weird questions are typically asked by the privacy office, and they're legitimate because they will help us to understand what we do, why we do it, and whether we should actually continue doing that. So these privacy impact assessments, this is another checkpoint. And the third narrative, which should be always communicated, is actually reporting of security incidents / data breaches. So it can happen to anyone, even if you send an email which contains personal data. For example, you work in HR and you attach, I don't know, like a job offer of a different person, and you send it to an incorrect recipient. This is a data breach because the confidentiality of the data was lost. And it related to another individual. So this will qualify as a data breach. It's a very simple one. And even in this case, the person who did that from HR should report this to the privacy office, so the privacy office can help to mitigate the risk for the poor individual whose data were disclosed. So this is very important, and these three narratives are relatively easy to understand. And from my experience, they typically cover most of the needs which company have. So onboarding a new vendor, starting a new project, and reporting an incident, these are key checkpoints. But with respect to all of these checkpoints, if a company would like to introduce them, it's very important also to promote basically a free discussion and no repercussions for either not meeting deadlines or maybe reporting an incident which I caused personally. If there is an environment when the company will fine or penalize otherwise the person who actually reported that incident, most likely people will try to hide it for the next time. So it's actually related to the friendly culture and privacy nurturing culture, which must be promoted by the organization.
I mean, that is exactly the point I would like to dig in, because I would say it is a cultural question. Because what you said with the three checkpoints, yeah, that makes sense. Absolutely, of course, it makes sense. But basically, it sounds like a huge bureaucratic monster. Okay, so people have their targets, they want to make business, whatever, and the feeling is whatever I'm doing, I have to integrate this privacy officer guy, so I cannot work anymore. Yeah, so something like that. And it's more or less the same with IT security, with IP in general. It sounds like a bureaucratic additional burden with no business impact, and basically it is slowing down processes and makes things complicated. So is there a way to show, despite of the fact you avoid problems? Okay, I mean, doing nothing avoids most problems. So when I'm doing something, when I want to make business, when I take risks, that typically means I accept simply that things go wrong. Otherwise, I wouldn't be entrepreneurial. Yeah. So how can you show from your perspective, from a data protection perspective? Is there a way to show that this helps business? It is better doing it in the right way. Is there also a narrative that data protection is not just bureaucracy? It helps really to make the things right.
Yeah, that's a $1 million question, sort of like. There are ways how to showcase that our program is not a regulatory requirement, but actually an asset or value generating program. But we don't have any like solid numbers behind to present. The way how I look at it is that if I imagine like myself being a CEO of the organization, I would like to have a privacy program in place because the very, very core requirement of any privacy program is that these guys will conduct something what is called the data mapping, data inventory, whatever you recall, whatever you want to call it. And as part of this exercise, we will map like all the data we have, what are the purposes for which we can use the data, and we will understand the data flows, which is perfect because we will finally start having control over these data, and we will realize
Absolutely.
maybe we conduct analytics on data which are older than 5 years. What kind of trends do we think we can derive from 5 years old data and things like that? Otherwise, no one will care because there will be no underlying mechanism to find this mapping and find like what is the as of state, what is the current state. So I think that this is one point how we can look at it, like having the data mapping in place will give a very good overview to the business owner or to the CEO of the organization. What does the company actually have? And this is a very good starting point. Apart from that, like if you do something meaningful and if the privacy program is meaningful, then it will be definitely visible to its customers. And these days, building trust and being transparent is something what is actually required by customers. And in both worlds, sort of, it doesn't matter whether you operate in B2B or B2C model. It is somehow required, or it is seen as a prerequisite that you know what you're doing and you're transparent on what you're doing. And without that privacy program, I would say that you wouldn't be able to claim that you know what you're doing because maybe you really don't know what you're doing.
Yeah, so before I say two comments to that, just to the community. So we are live here. The reason why we are live is that you can ask questions, you can comment, and you can ask questions here in the show. And Nora and I will try to pick that up and to integrate that in our discussion. So it would be great. So I see that we have quite a few people are looking that now. So when there is something which you would like to integrate to the show, just feel free to ask it, to write it in the chat. Okay, Nora, two things which I think are really interesting here. So this mapping thing, yeah, because it is the characteristic of intangibles that you cannot knock on it and it doesn't make any noise. And that means that you can't see it typically. And you have no overview, inventory, whatever. So when I talk with Donald O'Connell, so he's pretty much in this know-how protection thing. And it's the same thing with know-how. So most companies even don't know which know-how they have. So they have no clear understanding of that. And so how can you protect something which you don't know that it exists and in which forms? And I think that is a very good comparable situation to data, that especially the reason why we have the data is a wonderful aspect of, do we really make the best use out of the data which we already have? And I would say the bigger the companies become, the worse is that situation. Yeah. So we have this saying, when Siemens would know what Siemens knows, because Siemens is in Germany just a big company, and it is a saying that typically the company, not everybody in the company knows everything what the company could know or should know. And that is with data exactly the point. So that it is not known by the company which data is available and for what reason or what could be done with it. And the other thing which comes with the digital transformation, which I think is also extremely important, is what you said about transparency. So in the good old world, yeah, in the analog world, people had the strong tendency to be intransparent. So I keep my whatever data, knowledge, strategies, everything was mine, and I don't want that anybody knows anything about me. Just here's the product, buy it, and for that I have a brand. So, and more, that doesn't work. So you cannot hide anymore behind your brand and do whatever you want. Yeah. So so to speak, having a curtain. So the brand is a big curtain, and what happens behind on the stage is not interested. No, the brand is a frame, and within that frame you play the game, and everybody should see it. And in so far, transparency to creates that trust. And the more digital the business at the time, and don't have a personal interaction with each other. So I would say that both things, the documentation or inventory, and also this transparency, is a huge benefit to take care about this data protection.
Yeah, I agree, definitely.
That's
Among other things, obviously.
Point to explain why it makes sense.
Yeah.
Okay, I would like to come to another point, which I think is also very interesting. And so, so more and more companies act within a business ecosystem. So we see more and more corporations. So more and more the basic example is not anymore the island on which I am alone and I produce and I try to sell products. So the example is more and more that I am in a business ecosystem, in a network, and I interact with many others to create together value. And that leads us obviously to a situation where I exchange information. I mean, that's ultimately the way how to cooperate, that anyhow I exchange information. And what would you say when it comes to, so obviously this is a tricky situation for data protection. So what would you say, how could such a situation be treated?
That's a good question. Like with respect to exchange of information, it's absolutely natural that there will be exchange of data or information or whatever we call it for this particular purpose with either business partners who can be either like separate providers of services, and they will have their own accountability and liability with respect to what they do with the data, and also with those third parties which sort of act on our behalf, on organizations' behalf. In both cases, nowadays we have to, it's a vendor management sort of question. So we have to take care of what the vendor does, whether what the vendor does is actually permissible in accordance to, back to the transparency point, in accordance to what we have agreed on with the data subject whose data are being processed, that individual whose data are being processed as per the privacy notice, which we always have to present before we start collecting data, prior to the start of processing of personal data. And we have to make sure that we put in place also contractual arrangements which are necessary for that particular type of relationship. And here I'm talking about boring stuff like data processing agreements and standard contractual clauses, because there is a big topic of the so-called cross-border data transfer. To add another layer of complexity, we have to manage vendors if they are processors, and we have to enter into the data processing agreement, because in the end they will act on our behalf. But also the liability is with us, with the controller, with the company, because before we instruct this vendor to act on our behalf, we have to put this DPA, data processing, in place, because from the liability standpoint, what the vendor does on our behalf. So from the liability standpoint, this is relatively problematic, but in the end, like we all have many vendors who act on our behalf. So we have to put the contractual language in place. And this another layer is the cross-border data transfer, which is a big topic, especially this year, because the European Commission published last year this new set of standard contractual clauses, which is basically a template of agreements which we have to enter into anytime when we interact with a recipient of data. And here on purpose I use this word recipient, not a processor, because it can be a processor, it can be a controller, there are altogether 4 possible mutations between whoever is the sender of data and who is the recipient of the data.
Could you give us an example for that? So how does that happen? Just from the real world, because this language, this GDPR language, is sometimes so abstract that it's really hard to imagine situations in which that happens.
I can imagine that. Yeah, like, to be honest, all privacy offices and all organizations that have to comply with the GDPR, we are busy this year with this huge project on standard contractual clauses. So basically what we do, we review all our vendors, all third parties we interact with. And if this third party is from the so-called third country, which sounds like third world country, but in reality, for example, even the United States is considered as a third country, we have to enter into these standard contractual clauses with this vendor who resides in the United States. And what this agreement actually does in a nutshell, we will impose a contractual obligation on the recipient of the data, on this vendor who resides in the United States, to treat the data like the data never leaves Europe. So this is what it does. This is really oversimplified, but this is the core idea. And before we do that, we should also conduct some exercise, which we call transfer impact assessment. So we should first actually figure out whether we can rely on standard contractual clauses, whether these standard contractual clauses are not contradictory to some laws which will be stronger than a contract if these laws exist in the country where the recipient of the data resides. And there is a huge issue with the United States, by the way, because they have these laws, particularly laws which allow intelligence agencies to access data of European or European Economic Area residents. And this is what we are trying to prevent. But it is sort of like a catch-22 situation, because if you look at most of the technology providers which are used these days, including LinkedIn, we are now meeting over the LinkedIn platform. It's the United States provider and has to comply with the United States laws. So this is what, yeah, of course, yes. So this is what we are currently working on. And sometimes it's a proof of concept sort of work, because you have to do it. You are trying to do it to the best of your abilities, but at the same time, you know about all these caveats which are in there.
So that means, so my understanding is that with every third country, you have to understand, first of all, how are the legal provisions in that country to deal with data, and then you have to find out what is the difference to the GDPR requirements, and then you have to adapt your contractual situation to that country.
Yeah, you got it exactly right. And it's difficult because typically companies have a similar approach. We have done some legal analysis on those countries to which we frequently send data to. And here I use the word send, but it's about transfer of data. And this notion is particularly interesting because now, like, all companies are so busy to comply with this new requirement, but the notion of transfer does not have any official definition. So it's about transmitting data from Europe to this third country, but it's also about someone from that third country having access to data which still resides here in Europe. Both scenarios will constitute a transfer, which is interesting. So we basically had to look into
you wouldn't call it a transfer when somebody has access to it, but okay, I mean,
yeah, it's illogical, I know. At the first glance you wouldn't say that this is a transfer, but by definition of transfer, which actually doesn't exist, it is. And yeah, basically we had to look into all those transfers of data, look into the local legal frameworks, and based on those local legal frameworks, we are supposed to determine whether we can rely on SCCs or not. And the SCCs, they contain IT security annex, which is called TOMS, technical and organizational measures. So basically, you should protect the data in accordance to the particular legal framework and its local specifics. So, for example, if you expose data to the vendor who resides in the United States, you should put more measures in place to prevent this access of intelligence agencies to the data. So this is how you tailorize the contractual agreement to the particular scenario based on the outcome of the transfer impact assessment. But I'm sorry, this is a very boring topic and probably way too complex.
It's the reality.
It's a reality.
It's a reality, and it has huge consequences when you fail it. I mean, unfortunately, we are at the end of this evening of this IP Business Academy talk. I would like to talk with you more about that. So I'm happy when we switch to the chat on LinkedIn later on, when there are some questions, when you are available and give answers. In addition, I think we should make a blog post. So you gave me a big memo on that issues, and I learned a lot also this evening. So the promise is to the community that we have something then available on that topic, which is really, it has lots of similarities and it's very close to this IP issue. And to a certain extent, we can only learn here how, in this case, things are handled. So, Nora, thank you very much for taking the time and give us these insights. And for the moment, take care. Have a good evening. Thank you very much, and bye-bye.
You too. Thank you, Alex. Thank you, everyone. Bye-bye.